Okay, welcome back. And of course, our Supreme Court is, now starting to release a lot of their decisions from the previous session. A lot's going on there, and they seem to be still pretty active. I'm always honored when we have time to sit down with Mark Miller. He's the senior attorney there at the Pacific Legal Foundation. I can't say enough about this organization and the great work that they do on our behalf. They're frontline warriors on key cases in so many areas. You may want to go to pacificlegal.org is the website, pacificlegal.org. And check out what they do and support them, pacificlegal.org. Mark, good to see you again, friend. How are you?
I'm doing very well. Thank you for your kind words, Perry. Great to be with you.
Well, I mean them sincerely, so thank you for what you guys are doing. All right, some big decisions there. Supreme Court upheld the Tennessee law that bans gender transition. This is a biggie. It's being applauded and yet opposed. Can you walk us through the decision here?
Yeah, absolutely. The Scarametti decision, as it's known, Tennessee had its legislature, Perry, had adopted a law where they said that juveniles, anyone under 18, could not be treated for gender dysphoria with hormones and the like. It's not about surgery, but otherwise, for gender dysphoria, you can't have hormones administered to you, even if your parents consent. The legislature simply said, we don't trust the experts on this. Yes, there are experts on one side saying it's a good idea, others saying it's a bad idea. And Tennessee legislature said, no go. They said, adults, fine, adults can make decisions for themselves, but not children. And so some parents and their children who wanted this kind of treatment sued the state, said this violates our constitutional rights of equal protection. And it went to the Supreme Court, and the Supreme Court ruled yesterday 6-3 that Tennessee legislators do have the authority to do this. This is not discrimination against transgenders. There's a reasonable basis for the law, and the 6-3 breakdown was not surprising. It was the 6 Republican appointees and the 3 Democrat appointees in dissent.
Sotomayor's dissent was quite loud, wasn't it?
Yes, Justice Sotomayor, she dissented on behalf of Justice Jackson, Justice Kagan, and herself, although Justice Kagan wouldn't go as far as Justice Sotomayor. Justice Sotomayor said not only was this wrong, but she was sure the case should be reversed entirely, that this was discrimination. Justice Kagan said she thinks that transgenders are a protected class, and she would have sent it back to the lower court to decide, was this a proper decision, even though they're a protected class, because you can justify it, or was it improper? But the 6 justices in the majority, Chief Justice Roberts wrote an opinion, Justice Alito wrote an opinion, Justice Coney Barrett wrote an opinion, and Justice Thomas wrote an opinion. But Roberts spoke for the panel, spoke for the majority, and they said, no, this is not discriminatory. There's a rational basis for this law, which is to protect juveniles on 2 grounds. One, we're not treating all transgenders differently. We're just treating minors differently. And 2, the medical knowledge is uncertain. Justice Thomas went even further, and he said, I don't trust the experts, basically. I'm paraphrasing, and he said, we shouldn't either, and there's no violation of the Equal Protection Clause here. Any way you slice it, this was a big win for Congress and for state legislators. Basically, the Supreme Court said, we shouldn't be getting involved in making what are policy decisions. If you think juveniles should get this treatment, then elect legislators who say this treatment would be entirely fine. But Tennessee and about 20 other states say, no, we don't want this in our states. And that's what the legislators wanted. And the court said, we're not going to get involved. The Constitution doesn't speak to this.
Let me just, for a moment, Mark, just back up a little bit. Has gender dysphoria become a medical term based on provable science?
Well, that is much of what was being disputed, Perry, that this idea that children who may think they were born into the wrong body, if you will, whether that's a psychological issue, whether that's a physical issue, basically the justices were saying the science is all over the map, and we're not going to weigh in on one side or the other. Certainly, Perry, you and I both can look at the world these days and say 20 years ago, this is not the kind of thing we heard much about. Some would say this is, sort of a hysteria, no different than, say, the tulip hysteria hundreds and hundreds of years ago, just in different wine bottle, but the same concept where society gets hysterical about issues, and that 10 years from now there'll be a different issue. I don't know. That's beyond my legal degree. But what I will say is the Supreme Court said we aren't smarter than the rest of the country. The legislators should be the ones to decide this, not us.
Yeah, the reason I asked that because, if it's been officially diagnosed as a medical term, is it in the area of all the baloney that we got through COVID?
Perry, I think that's a great comparison. And I heard a Supreme Court expert say, is this like if you were diagnosed with HIV in the 90s? Could you be discriminated against?
Right.
And my thought in response to that, Perry, was I don't think so. I don't think it's the same. You either have HIV or you don't. Here, Justice Coney Barrett, in her concurrence, she wrote her own opinion that Justice Thomas joined, and she said this gender dysphoria issue, it doesn't always come in the same platform. Sometimes children develop it when they're 5, 10, 15. Sometimes people grow out of it. Mm-hmm. And she said, that's not really what we think of when we think of discriminating against, say, someone who's a minority or a woman or your alienage, that you're from another country. There, you either are or you're not. Here, Justice Barrett said, no, we don't know. Sometimes, it's not obvious when you present that you have this condition, or like HIV.
Yeah. I've just been doing a lot of research and thinking on this only because it's so prevalent at state levels and for various reasons. It moves over into the mental health issue and all of the things that tie into that. It's really a loose cannon. I want to come back to another case here that's certainly even impacts an organization like yourself and ours, and that is the First Choice Women's Resource Center on disclosing donor lists. This is a big deal. What's your take on this one?
Yeah, this one is remarkable, and your viewers absolutely need to know about it because the Supreme Court has addressed this issue before, but right now the left side of the aisle doesn't want to accept the answer. And what it is about donor lists. If you donate to a nonprofit, the Supreme Court has said for decades that you have a right to be anonymous, that a nonprofit like theDove, my guess would be, or Pacific Legal Foundation, or the Pro-Life Center in New Jersey that is the subject of this lawsuit, they have the right to keep their donors' names confidential. This was a decision from the 50s where racists in Alabama wanted to find out who was donating to the NAACP. And the Supreme Court said in the 50s that no, you have no right to that. Those people have a First Amendment right to be confidential. Their donation is speech, and they don't have to tell you that they're donating. And now the left, liberals in New Jersey, the Attorney General of New Jersey, are trying to avoid that precedent and say that they can get the donor lists of a pro-life center that helps women who have chosen life. And so the Supreme Court intervened to say, because so far the courts have said, yeah, it's okay that the pro-life center could be ordered to turn over their donor lists. And my guess is, Perry, the Supreme Court is going to say once again that no, you were not entitled to those lists. It's obvious this is just designed to harass people. And it's wrong and it's unconstitutional. And yeah, at Pacific Legal Foundation, we absolutely would agree with this pro-life center, even though we don't do pro-life work per se. You know, Perry, that I'm the chairman of the board on the side for Americans United for Life, so I am pro-life. But the bottom line is, if you're a nonprofit, you should not be forced to give up your donor lists.
Is there a danger of a nonprofit that just voluntarily gives that list out?
I mean, isn't it the truth, Perry, that you and I, we know the law. Certainly the nonprofits I'm involved with know the law, and I'll make sure, whether it's Americans United for Life or Pacific Legal Foundation, that we don't give up the names. But there's so many nonprofits that they don't have lawyers on their board necessarily who know that they don't have to respond when the Attorney General orders them to turn over the name lists, that they can actually fight it. And maybe if they could fight it, they can't afford to fight it. And that's why it's important for the Supreme Court to weigh in resoundingly here. And I think they will. I think you'll see a 9-0 decision. I don't like to make predictions, but here the law has been black and white for so long, really, like I said, since the 50s with the NAACP being harassed. I think the Supreme Court's going to make it clear this is wrong, and the New Jersey Attorney General way out of bounds to be harassing a pro-life crisis pregnancy center.
Well, it will dry up nonprofits.
Yeah, that's exactly right, and it's why, thankfully, the Supreme Court justices, even 5 years ago, this issue came up where the California Attorney General, originally it was Newsom, and then who's now the governor. And so when he became governor, it became Rob Bonta. And they were trying to harass Americans for Prosperity, another nonprofit on, not surprisingly, on the conservative side of the ledger. And they wanted their donor lists. And the Supreme Court said no. So it's a little surprising that 5 years later we have to deal with it again. But I think the Supreme Court will get it right again.
Is it true, Mark, that part of that argument is politicians, candidates do have to report, I should say, in their CE reports who donates to them. Is that part of the argument?
I think that's as much part of the argument so much as it creates the confusion, Perry. There are those who would argue, and I might, if I'm feeling very First Amendment-ish, that you shouldn't have to turn over who's donating to you as a campaigner, that violates their First Amendment rights. But at least until now, the Supreme Court has said that's different, and that, yes, you do have to turn over who's donating to your campaigns. And so I think that you could argue that's what the Attorney General of New Jersey or the Attorney General of California 5-6 years ago were relying upon. But the fact that there's confusion on the issue doesn't mean that the law is not plain.
Yeah, because to that point, a lot of people won't donate to candidates because they don't want to be exposed, or they use other means to get the money to them, which in itself creates money laundering.
Well, and as you know, Perry, it's really outrageous the way the political world has been. Violence has become a regular issue, whether it's those legislators in Minnesota last week, or the president had 2 assassination attempts, or at least 1 assassination attempt, and one somebody who didn't actually get didn't shoot, but got arrested. And of course, we remember what happened in Arizona with Gabby Giffords and Steve Scalise. And so this idea that we're going to now start exposing donors, it just seems like people are trying to intimidate. If you're a pro-lifer and you donate to that pro-life center in New Jersey, or to theDove, or to Pacific Legal Foundation, and that's really wrong.
Yeah,
and it's a sad part of our modern life.
Yeah, I just. Okay, thank you for being there, because this is so big, really big. All right, let me take a quick break a little early because I got some big questions on the other side. Let me say to our viewers and listeners, check out pacificlegal.org. That's Mark's foundation right there. There's a picture of their landing page. You may just want to go through there and take a look at some of the cases they're involved in. If they weren't there, I don't think we would be here. They are just really frontline warriors in a lot of things that we hold dear. So check them out and support them, pacificlegal.org. We'll be right back. Okay, welcome back, and such an honor to have with us Mark Miller. He's the senior attorney there at Pacific Legal Foundation. Let me encourage you to check out their website, pacificlegal.org. And Mark and his team, I'm telling you, they just outstanding. They're there really in our behalf. So check it out and support them, pacificlegal.org. Mark, one of the big things going on, especially here on the West, is what's going on with the National Guard. Of course, you know the story, and the California National Guard being dispatched in Los Angeles. The president turns around and nationalizes the Guard. There's some conflicting terms here. We have the word National Guard. You have the California National Guard. And the president wants to nationalize that. Of course, Newsom gets all uptight and says no to this. What's your take on this mess?
Yeah, I mean, it's an excellent question, and I think it may be going to the Supreme Court, Perry. The president decided as commander-in-chief that he would, the verb is federalize, that he would take the state National Guard for California and order them as commander-in-chief to get out in the streets of Los Angeles and make sure to stop any civil unrest, to do so peaceably, but to be there to make it clear that violence was not the way we do protests in the United States. Nonviolent protests like Martin Luther King is what we prefer. Governor Newsom said, no, this is the California National Guard, and if I don't want to go along with that, then I get the final word. I was very surprised by Governor Newsom's position there. As you know, Perry, I worked for Kristi Noem. I was her chief of staff and general counsel. And we addressed this same issue about 4 years ago, where Governor Stitt of Oklahoma wanted to block Biden from forcing National Guardsmen in Oklahoma from being vaccinated with this experimental vaccines for COVID. We looked at that in South Dakota, and I had to tell Governor Noem, we can't, we will lose that fight. President Biden is commander-in-chief, and we may disagree with that vaccination order, but between your power as governor and the president's power as commander-in-chief, you will lose. So we didn't get involved, and Governor Stitt lost his lawsuit. I may respect him that he wanted to defend his state National Guardsmen who didn't want the vaccine, but bottom line is he lost. And you can make an argument that that's really inappropriate. even though I'm not making the argument, you could say that someone, it's like a lieutenant suing the general. Here, same thing, shoes on the other foot. Just because Governor Newsom doesn't like what the president was doing, he doesn't really have any leg to stand on. Surprisingly, a trial judge, a district judge in San Francisco said he was right, but the appeals court in California, the Ninth Circuit Court of Appeals, had argument earlier this week, and they indicated they're going to rule for the president, that we have precedent going back 150, almost to the beginning of the country, 150 years, 200 years, that says, no, the president's commander-in-chief, you may disagree with his decision, but he has the final say in when the National Guard is used to quell civil unrest. And so that's where I think we are. It may go to the Supreme Court or it may end. It depends how much Governor Newsom wants to make a political grandstand out of this.
The complexion of the Ninth Circuit's changed, so it's good to hear this. And do you think it'll end there?
And that's what's interesting is you're right. The court has moved a little bit to the right. It's still a court that we would call a liberal court among the courts of appeals that cover the country, that are one step below the U.S. Supreme Court. Here you had 2 Republican appointees and 1 Democrat appointee on the panel that heard the arguments about whether Governor Newsom could do this and overrule the president. And all 3 judges made it clear, this was just a few days ago, that they don't think Governor Newsom had that power, that the precedent was clear, even the Democrat appointee. And I think that's correct. And to me, that was reassuring, Perry. I've been on with you earlier this year, and I've been a little disappointed with judges who seem to think they can just make things up. I believe very much in the rule of law, and I know most judges do too, most lawyers do. But when judges start just doing what they think because they don't like what the president's doing, they send a message to the people that it's not about law, that it's about power. And that's 100% wrong. And so I applaud, hopefully in advance, the Ninth Circuit for getting this right. And then hopefully Governor Newsom will do the right thing too and stand down. But who knows?
Well, at the end of the day, the National Guard is military, therefore commander-in-chief in charge. I mean, it's kind of simple, isn't it?
That's, Oliver Wendell Holmes, 120 years ago, he said, the law is a prediction. The lawyers have to predict what courts are going to do. And here, it should be pretty easy to predict that the president's the commander-in-chief, he's the final word. So when the judge in the case initially said, no, Governor Newsom can overrule the president, that was frustrating because that was not what you would predict the courts would do. And so I applaud the Ninth Circuit, as I said earlier, that society needs to depend that the judges who enforce the law or interpret the laws will interpret them neutrally and fairly, not because they're partisan, not because of what they want on policy, but rather what the law demands. And hopefully that's what the judges are going to do here. And hopefully the Supreme Court is going to rein in some of these district judges who have gotten a little bit out of bounds with their rulings.
Okay, I want to come to that, but one more point. Most of this hinges on the fact that the president is trying to protect national government employees and facilities in L.A., correct?
That's correct.
Okay.
And Perry, I'm reminded, just to follow up on that, I'm reminded of the 60s. And there you had Governor Reagan, was governor of California, and he was having to put down civil unrest. And it wasn't a partisan issue in the 60s. You had Democrat governors. I have a picture of Notre Dame behind me, the Golden Dome. And the president of Notre Dame, Father Ted Hesburgh at the time, he's a well-known Democrat. But he absolutely stood with Ronald Reagan metaphorically and said that the students on Notre Dame could not use violence. If they were going to use violence in protest, they would be kicked out of school. And he became a leader across the country. And it showed that this was bipartisan, that we do not protest with violence in the United States. Whether it was Governor Reagan back then, Governor Newsom now, we have to recognize that the power of the government to put down violence is not something that we should be questioning, even though we would prefer we don't have National Guard on the streets. It'd be better to be peaceable.
Okay, I want to come back to these continued injunctions coming out of these district courts. You and I have chatted about this, and it doesn't seem to be ending. Now we're discovering all this time there's a little bit of an ambiguity here where the jurisdiction of the district court needs to be clearly defined. Where do you think this is going to go, Mark?
Well, right now the Supreme Court, Perry, is looking at it through the prism of the birthright citizenship case, which is the question of whether President Trump can sort of change the law. For basically since the 14th Amendment was ratified, the courts have said that if you're born here under the text of the 14th Amendment, then you are a citizen, even if your parents were not here legally. and President Trump is trying to change that. Well, that case is in front of the court, and one of the issues is that the trial judges have said that the president is wrong. He can't change that, and they are blocking the entire country from agreeing with the President Trump, even though a district judge just covers like one portion of the country, usually a city or what we call a district. So San Francisco or New Jersey, there's one district for New Jersey, it's the entire state. But here the judge of New Jersey would say, I can rule for the whole country that the president can't do this. So the Supreme Court has to wrestle with two issues in the case. One, can they rein in these district judges and say, no, you don't get to speak for the whole country, you just speak for your district, you're a district judge after all. And then two, they may weigh in on the birthright citizenship issue, or they may say, let's have later arguments on that. Nationwide injunctions, though, are what we're talking about, Perry, and I do think you'll see the Supreme Court rule on that in the next 2 weeks.
So if the Supreme Court tells the district court that you have to stay within your jurisdiction, do you think that'll be codified by Congress?
Congress is absolutely talking about different ways to codify that power. One thing they're doing is sort of trying to threaten judges. It's not easy. It's an interesting interplay of the separation of powers. Congress can only impeach and remove federal judges. That's their power. But also, Congress creates the district courts. The Constitution only creates the U.S. Supreme Court. And then all the other courts that we talk about, the Federal Appeals Court, the Federal District Courts, Court of International Trade, and the tariff case that we've talked about before, these are all created by Congress. So what Congress giveth, Congress could taketh away. But I think more likely you would see Congress pass a law that tries to clarify that district judges only rule in their districts, but you could also see Congress saying, well, if the Supreme Court fixes it, we won't get involved because of the separation of powers.
Okay, because you know what's so interesting about this? It's I don't know if it's ironic or hypocritical. These district courts need more judges. I mean, their caseload is unbelievable. You would think they would focus their attention there instead of being politicized to get outside their district.
Perry, that's a really perceptive question. In fact, right there at the end of the Biden administration, there was a bipartisan effort to create a lot more district judgeships to address the exact issue you're talking about. And it was trying to be set up in a way that would be nonpartisan so that the current president would get X number of new appointments. And then the next president, we wouldn't know, that would be 4 or 8 years later, would get Y number of appointments. So both Democrats and Republicans tried to do it in a nonpartisan way. But President Biden vetoed it. And so you might say that was a mistake on his part, because if he had not vetoed it, he would have gotten to make some of those new appointments, new judges. And instead, he vetoed it because he didn't want to risk Republicans getting the appointments. And now what you could see is President Trump maybe getting more new appointments because Congress will return to this issue. It absolutely is a crisis. Just like you said, there are not enough judges for all the cases that we have in federal court.
So, coming to the end of the session, do you think that you'll see a justice say, I'm done on the Supreme Court when this is all over?
I don't think so. It's certainly what everyone is trying to guess. I mean, Justice Alito, Justice Thomas are, I think, the oldest justices on the court. I don't think either of them have given any indication. Justice Thomas, for his part, is approaching the record length of a justice ever serving on the U.S. Supreme Court. I think he reaches the record in 2028. So I could see him perhaps breaking the record and then retiring, and while President Trump is still in power. But I think most people who predict that he will want to stay on. And why shouldn't he? He's absolutely lucid. He's one of the most incisive minds on the court. And of course, Justice Alito, he has done fantastic rulings over the last several years. He is, other than having a fight about his wife putting the upside down flag on her house at the Jersey Shore, he's liking his job just as much as he ever has. So I don't think we'll see a retirement this year, but maybe over, towards the end of President Trump's second term in office.
Okay, I would understand that. So any other cases that we're missing that you're tracking there?
I think a good case for your viewers to look for, Perry, is Texas's law to say that everyone has to prove up how old they are to look at those unseemly sort of porn sites. The Supreme Court's considering whether that violates the adults' free speech. The idea of this law is to protect children, just like that Tennessee law that we just talked about earlier with transgender treatment. And I think the Supreme Court will uphold the Texas law and say that indeed it doesn't violate anyone's rights to just require you to prove you're an adult before you look at those kind of websites. That's one of the most interesting cases left to be decided over the next 2 weeks.
How in the world do they police that?
Well, that's outside my ken. We would need an IT person for that, but I think they can. They make you show ID or something to that effect when you log in. Thankfully, I don't know exactly how that would work.
Okay. So about a minute left here. What are you guys working on lately?
Yeah, so at Pacific Legal Foundation, we are really focusing on environment and natural resources law. This is one issue. We fight for property rights, and right now the administration is very much in line with what we think, which, for example, the timber industry. We need to free up the timber industry, the mining industry. We need to free up people who are trying to mine to get the precious minerals that we need for our military, for example.
Mm-hmm.
But we have so much red tape. So we're fighting against that. We're working with the administration, Department of Agriculture, Brooke Rollins, Department of Interior, Secretary Burgum, to try and free up. And then when we have to, we will sue. But right now, we're pretty happy with the administration, and we're just trying to get them to do things more quickly.
Please let us get back into these forests after forest fires and clean them up.
Exactly. That's been one of the real mistakes we've made over the last 50 years. In trying to, quote, protect the environment, we're actually causing forest fires. We're not managing our national lands the way we should, and we should allow farmers and ranchers to get in there and manage them for us. That really would be a better way to manage the country. It's the way we did it from the founding of the country until the 1970s.
Yeah, right. Interesting stuff. Mark, thank you. Thank you for your time. Blessings on your friend. Let me say to our viewers and listeners, check out the website, pacificlegal.org. That is the place. And fascinating, some of the things they're involved in. Go there, check it out, support them. Again, Mark, thank you. We value your time. God bless you, my friend.
And God bless you right back, Perry. Thank you.